Arizona Court of Appeals, Division 1 is now in session.
Please be seated. We're on the record now in case CV 15-0092, Michael Soto versus Anthony Sacco. This is the time set for oral argument. Counsel, let me explain some things about oral argument that you may be aware of. First of all, we have read everything in the case. We've read all your briefs. We're very familiar with the issues. Second of all, I want you to keep track of your time. You each have 20 minutes to present your argument. Counsel for the appellant, you can set aside some time for rebuttal. The other thing I would tell you is that these proceedings are being audio and video recorded, so they'll be uploaded to the court website. I just want you to be aware of that. Does that make you not want to do oral argument today, counsel? I saw you kind of shudder when I said that. There was an issue brought to my attention. Is it Mr. Abernathy?
Yes, sir.
You wanted to bring in some exhibits or something? Did I misunderstand that?
There's a part of that board right there.
Board.
Okay. We've looked at the exhibit. Is that what you have, the x-rays?
Yeah.
Okay. I don't want you to use that during the oral argument, okay? All right, your argument, counsel. And I think I maybe was a little abrupt there. We've read the record in this case, and we understand the issues and the injuries. If you had some type of demonstrative exhibit, I think that's probably something we would consider up here, but I mean, this isn't a jury sitting up here, so that's the basis for our ruling, okay? Go ahead.
I understand, Your Honor, and I'd like to reserve 5 minutes of time if I could.
Fair enough.
May it please the Court, my name is Jim Abernathy, and I'm here before you on behalf of Michael Soto, who is the sole remaining plaintiff on appeal. His wife's case was resolved at the lower level after the trial. I just want to start by saying there's a reason why this case, unlike 95% of cases, actually went to trial. And the month before the case went to trial, as we say, there was a stipulation for liability, which would have probably made 98% of cases go away, and it didn't. And it didn't because I think there was a simple reason why not, and that was the two parties in this case saw this case dramatically different. The defense continues to this day, even after the jury verdict, to essentially tell this court and anybody else who will listen that it was simply a broken arm that Mike suffered. He got better. He's moved on with his life. And so essentially we feel sorry about it. We feel bad about it. But let's get on with things. Our position was that Mike Soto's life had changed as a result of this injury. And so you had two very, very different competing theories in the trial court.
Sounds like the stuff that is made for trials.
Well, that is why there's trials. Yes, Judge. Judge Kimmel. Yeah, that's why there was the trial. Because we had tried to get the case resolved and couldn't. And in talking to my clients at the time, both of them, they understood from going to the mediations that the ultimate decider of their value of their case would be the jury. They were told that repeatedly. And that they were putting their fate in the hands of others, strangers, juries. And they accepted that. And they went through the trial. And what I'd like to point out, because I know there's a lot of trial experience here and actual practice as well on this panel, that there was no theory, there's no claim that we did something at that trial that was untoward. You would probably look in here and say, well, what did this lawyer do? What did the plaintiff's lawyer do? There were no shenanigans. There were no game playing. I didn't try to allege that the unborn child, Julie was 7 months pregnant at the time. I didn't say things
Counsel, let me just ask you. I mean, I have to ask you.
Sure.
So how did the judge abuse his discretion in granting the remittitor? What was the abuse?
Well, I think that he essentially replaced his judgment as to the value of the case with the jury's.
Was there any? Do you have any evidence that the trial judge considered something that wasn't in the record, anything like that?
No, I don't think that he considered the record fully enough. And one of the things, if I can try to answer your question, that if you look even at the questions, and we try to point that out a little bit in the record when we were going for the motion for new trial, his first question to me, and you saw I didn't try to attack the trial court, didn't do it at the trial, don't do it now, but one of his first questions to me was, well, when did you ask for when did you hit them with what you wanted? In my closing argument, Your Honor. When did they do it? Their closing argument. That question then was followed by, well, did you ask Mr. Soto, how come you didn't ask Mr. Soto how much he wanted when he was on the stand?
Who asked that question?
The judge asked me, why didn't you ask Mr. Soto, how much money do you want for your injuries? And I kind of looked befuddled, and I said, because that question would be completely inappropriate. And then I said, well, you're the judge, so if you don't think it's inappropriate, then it wouldn't be inappropriate. It's not up to me to make that decision. But I've never asked a client on direct exam, Mike, how much do you want for this case? There's no requirement that I ask for an amount in my opening statement.
Unless things have changed, we don't ordinarily see that.
A lot of times judges don't like it, to tell you the truth, and I do cases in other states. Judges say opening statement is not evidence. They say that it's not to be argument. They say you're supposed to say what's going to happen in the courtroom. There are judges that are not too happy when you start strutting around in the opening saying how much money you want for a case that you haven't put on a shred of evidence in. So,
can I get back to Judge Gould's question, though? And I want to frame it with some language from our Supreme Court in the Creamer versus Troiano case, where they survey 30 years of Arizona jurisprudence on both additors and remitters.
right.
And they say it's interesting to note that in every single one of these cases, we affirm the trial court's order. That in itself should carry a strong inference that one of the key factors in our decisions is to give the trial judge the benefit of the doubt, and then the court goes on to say that they had the opportunity to view the witnesses, demeanor, and that their judgment will nearly always be more soundly based than ours can be. So that's a very high hurdle, and I'm struggling with what in this record would get you over that hurdle.
And I appreciate that, and I think that the discretion to the trial court is a high hurdle. And I accept that. I think we want to have finality and we want to give the judges discretion. But I think if you look at Judge Winthrop's recent opinion in PETA, where he says that we need to look at the whole record, we need to see here. There is also a sanctity to a jury verdict, which is at some level supposed to be even more, given more sanctity than the judge. I mean, when he says $250,000, he is replacing his judgment with that of the jury.
But by definition, that's an additor or remittitor.
Sure, yes, and I don't think that they can be done except in exceptional circumstances, which is shocking the conscience.
Well, that's a new trial. The passion and prejudice shocking the conscience, then the court has to order a new trial, not an additor or remittitor. But the case law, I'll give you that some of the case law, especially from our court, has been a bit muddled in stating the standard, but the Creamer case and even some earlier Arizona Supreme Court cases are very clear that it's a deferential standard. Now, we do have a recent case saying it should be for the most cogent reasons, such as lack of evidence to support the damages awarded, but that's ultimately, and I'll give you, Judge Gordon didn't say that initially, but ultimately that's what he said here. So I'm just struggling with how to square your argument with the established law in this area, which is a bit of an outlier when it comes to the sanctity of a jury verdict.
You know, and I agree with you when you use the word muddled. I mean, I don't want to talk about court opinions being muddled.
We can say that.
Yes, you can, and I can agree with you. I do think that it's somewhat muddled, and I think that when you look at the opinions from high and low and you take them all together, you see certain premises or certain things. And one is that you start from the position that the jury verdict is supposed to be upheld other than if there's some exceptional circumstance. We shouldn't be interfering with what the jury spent 3 days doing. That was their job to do. And I think you start there. And Judge Winthrop, I think, yes, in language talked about fairness. He started talking about concepts about, you know, we have to intervene. He said we have to look at the whole record. I mean, they criticized me in the brief for restating the facts of the case. That's exactly what you need to do when you're considering what's going on in the remittitor, what exactly happened at the trial court level. And they didn't want to go through the facts of the case. I'll say this about Judge Gordon. If you want to know what he did, I think he should have told you what he did. If he wanted to remit a case from $700,000 that had $40,000 in stipulated medical expenses, 9 screws and a rod, and testimony that this had permanently affected this young man, who was less than 40 at the time, with a permanent scar on his arm, then he should have said why he was doing it. And if you look at the transcript of the oral argument after the post-trial motions, the defense attorney said to him, you know, we need a reason for this. We just want to make sure you have a reason for it. And it's not like I objected to that. I thought a reason would be nice. And Judge Gordon struggled. If you read the transcript, Judge Gordon says, well, and then I think he said 59A5, if my memory serves me, which is just the verbiage of the rule. Why didn't he, if it was that apparently over the top as far as a verdict, I would have assumed he would have had no trouble whatsoever.
I may have the hearings, one hearing confused with another perhaps, but I thought he said, I find it to be excessive, and then he said, I'll issue an order that has that in it.
Right.
And he did the next day.
Yes. And he did and that's 59A5. But that's not telling you.
He didn't tell you why it was excessive.
No, he's not giving you any guidance as to, well, is there something he didn't believe here? Remember,
what required him to do that? And I will say, even before the supplemental authority was filed, we were all over the language in Hancock versus Linsenmeyer, which specifically says that 59M doesn't apply to 59I rulings. So, yeah, it would be nice, and we often say the better practice is for trial judges to give some reason. It gives the parties a little more comfort in the soundness of the reasoning, but there's nothing we can hang our hat on that says he had to do it, is there?
Well, not if you feel that the rule doesn't require him to do it. But again, it's not just for the parties, but I really think it's more for you than actually for me, because again, he has tampered with the sanctity of the jury verdict. And there should be a reason as to why he is doing that. And I think even if you say he's not required to do it, having had it brought to his attention by defense counsel that we need to know the reason, and then he says, well, 59A5, okay, that didn't tell anybody really much about anything.
But had defense counsel argued more than one reason for asking for a remittiture or new trial?
Well, they had the whole, the laundry list. That's what we talk about.
But it was all under the auspices of, hey, this jury obviously did something wrong or failed to follow instructions because this is way too high.
Well, let me ask you.
Isn't it? I think it was all under that umbrella.
Yeah, penumbra, the umbrella. I'd agree with that. But I'd say this. What Judge Gordon also decided then is, as a matter of law, the most that this case could have ever gotten from a jury to be constitutionally valid was $250,000, which was less than even the defense was suggesting in their own pleadings.
Counsel, I want to get back to my original question. So I understand your arguments, but our standard of review is abuse of discretion. So what are we finding that is an abuse of discretion? What do you want us to say that was an abuse of discretion? When you look at, for example, insufficiency of the evidence on new trial motions, you look to see if the judge failed to consider all the evidence. In their findings, they only considered a portion of it and ignored other important evidence. Or the court made findings that were not based on facts on the record. Those are the types of things that we look at on this kind of review. So what is it that he abused his discretion on, other than you wanting us to kind of make sort of another judgment about how he judged the jury's verdict? That sort of seems to compound the problem that you think exists regarding the sanctity of the jury verdict. If we start engaging in the same type of freewheeling, ground zero examination of the evidence, right?
Well, to answer your question, or at least to attempt to answer the question, because the judge gave so little, you're now asking me to sort of demonstrate on the record what he didn't consider and did consider. That's not possible. No one could do that. No one could do that, so you can't. Justice Winthrop, in the recent Pettit case, talked about reviewing the entire record. And so when you talk about muddling, I think that Justice Winthrop really wanted to say, we're also judges. Most of us have also been trial court judges. And I think he really wanted to say, kind of like pornography, we know it when we see it. This is not stuff that's beyond our ability to judge. In this case, all we have is the result, that he took a judgment that was for $700,000, and he reduced it to $250,000, finding as a matter of law that that is the most that that case could do. It's not supposed to be what his opinion is either. It's supposed to be that which he thinks is the most that that jury could have ever utilized there. And I just think when you look at the facts of that case, to say that $250,000 is the most that ever could have been done. And I guess I'd say to you as well, if that were the case, then you don't use the settlement numbers and put it to the judge. You don't start talking about what the jury said after the verdict. I mean, these folks were stretching for any reason they could find to give the judge about that verdict. And really, I get back to what Judge Gemmell said earlier. This case was a jury case because the parties did not agree about the level of damages. And the judge essentially, in that remitter, simply replaced their judgment with his own and gave no real reason. You can say it's not required under the rule. You can say it's better practice. But when you look at that record and you see the transcript of the oral argument, he doesn't have anything that he's relying on. He just did it. He did it himself.
Before you run out of time, because you want to save time for rebuttal, we've sort of jumped the gun because, as you know, we have a question about our jurisdiction as to whether the notice of appeal was timely filed, and we asked the parties to be prepared to address that. Let me ask you one question that I think you'll agree to. If Judge Gordon had signed his November, I believe, 19th, 2014 minute entry, would the time to appeal have begun running on that date? Under 59I?
I think I'd agree with you. I mean, I'd have to study the rule closer to give you a real, because he gave me time then to, the rule is that little, where if you don't accept it, it's deemed rejected, et cetera, et cetera. My view was it was unsigned. And what I wanted to say about that as well is this was no secret to anybody. This was like the elephant in the room. We had a hearing about it. And I just say, when you have a firm with an appellate department, that's not an issue they're going to miss. And so.
Well, we have an independent
Correct.
duty to look at our jurisdiction, so it doesn't really matter what the parties think about jurisdiction or even whether they've waived it themselves. And it seems at first reading of 59I in the comments, it's intended to be a self-executing rule so that no further order is needed. Now, the wrinkle in this case is Judge Gordon's first order was not signed, which I think assists you arguably, but I'll be interested to hear their position, because I think if it had been signed, the time to appeal probably would have begun to run at that point.
Yes, and I think I would have, out of fear, I would have appealed. But when I had an unsigned minute entry order, and then I'm reading the three, I call them the trioca, the three musketeers of cases, and Judge Gemmell, has written on this about why do we keep getting these premature appeals.
More than I wanted to.
Well, more than, yeah. So our plea, it does more than arguably help me, but I read those cases to say, ever since I was a young lawyer here, all I keep reading from the Court of Appeals is why do we keep getting stuff that's premature? Why does stuff keep coming up here out of order? Why do we have to keep sending it back down? And so ever since I was a young lawyer, it got drilled into me that you need a signed order for finality. And that's when the tambourine bangs and you can now do something. And I got back into that court as fast as I possibly could because I was concerned over that issue. And I didn't hide anything. I put it on the table. And so I understand, Judge Downey, that you have an independent. That's right. They can't waive it. I can't waive it. But, boy, nobody in this case read the rule the way they're now talking about it in their appellate brief to suggest that this is okay. They don't even cite the three cases that we cited because we were doing the paperwork simultaneously. They just ignored all the cases, in my view, that were on point on that issue. So I've got 4 minutes and 25 seconds left for rebuttal unless someone else has any questions for me.
No, thank you, counsel. Counsel? Mr. Ackerman, is that right?
That's correct. May it please the court, my name is Justin Ackerman, and I'm here for defendant appellees Anthony M. Sacco, Total Transit, Inc., doing business as Discount Cab, and Discount Enterprises, Inc. I would definitely like to start with the court's questions on jurisdiction. Being in the appellate department here, we do have an adage, and it's to file your notice of appeal early and often, and I think that is what should have happened in this case.
The reason I think it may be timely here is because Judge Gordon did not sign his November order, and we've got a lot of case law, including the Tripati case, which I believe Judge Gemmell wrote, but it's still correct, to say that an order,
In spite of that.
has the effect of granting or denying a new trial has to be signed to be appealable. So I think that may be the wrinkle here. Otherwise, 59I is a peculiar rule that appears to be self-executing.
I 100% agree with you that Rule 59I is a very peculiar rule. In fact, I've looked at other jurisdictions and I could not find a similar analogous rule, nor could I find one in the federal rules of civil procedure either. And the Tripati case deals with Rule 59A. This case involves Rule 59I, which again has that unique language that is self-executing. So I think that in and of itself, the plain language of Rule 59I lends itself to not require a signed final judgment in order to start the appellate clock. And as a further distinction of the Tripati case, Rule 59I requires that the time for appeal starts when it's the expiration of the time to accept or reject the remittitor. It's not from the unsigned minute entry. So for that reason, I think it's a further distinguishment from the case law interpreting Rule 59A. And there are other exceptions within the rules that don't require a signed final judgment to appeal. I'm only aware of one, in fairness, and that's, excuse me for a second, that's under rule, it's the habeas corpus under Rule 59, 58F, I'm sorry. And so there are exceptions that the rules have recognized where you do not have to appeal from a signed order. And I think Rule 59I is one of them. So for that reason, I think that the time for appeal
What was the habeas rule again?
it's Arizona Rule of Civil Procedure, Rule 58F.
Okay, thanks. Is this a publication-worthy issue?
Absolutely. I absolutely think the court should publish on this issue and clarify. No bias, but in my position. And I also don't think that any kind of equity concern really saves plaintiff on this issue. This was discussed in the telephonic conference that occurred after plaintiff filed his motion for clarification. And in some substance, the colloquy between plaintiff's counsel and the trial court was that, yes, I can issue a signed final judgment, but you should issue your notice of appeal within 30 days from the expiration of the deadline to file your acceptance or rejection of the remitter. And plaintiff's counsel, quote, says, yes, I agree.
You know, we haven't, in most of the recent jurisdictional cases, emphasized the trial judge's intent, although that is found in some of the cases, including the Supreme Court cases. And I think the reason we haven't is we've been trying to write some logical rules that could be followed without having to discern somebody's intent. But in this case, the Superior Court judge said, I intend this to be the final appealable ruling, the one that was appealed from. Why shouldn't we tip our hat to that and move on?
He also said that the Court of Appeals is the one that determines its jurisdiction.
Yeah, that's right. He did say that, didn't he?
He did. And so I think it is this court that determines whether or not an order is final.
Couldn't let him help us.
No, I don't think so. So I apologize, Your Honor. So I think for those reasons, this court does lack jurisdiction. The appeal was untimely. And plaintiff could have filed his notice of appeal after this telephonic conference and still have been timely, but he didn't. So I think that's just another point to consider. Unless there are other further questions on the jurisdictional issue, I could move to the merits, but again, I think the jurisdictional issue is dispositive of this case.
You might want to move on,
Okay.
just in case.
Just in case, okay. Regarding the merits, I think you hit it right on the head that the standard for this case is it's not just abuse of discretion, in my opinion. It's almost abuse of discretion plus.
All right, I got to stop you right there.
Sure.
Oh, you got him all riled up just having said that.
And what's the rationale for that? I mean, I understand. I know what the cases say. Mr. Ackerman, of course, you're right. I mean, there's this strong language, but what's the rationale for that? Why should an appeal from a remitter be abuse of discretion plus over the grant of a motion for a new trial? What's the rationale for that?
The sanctity of the jury's verdict is absolutely true. It is entitled to that deference, but when a trial court exercises his discretion to override that ruling, I think that entitles that decision, which is an even higher use of discretion.
Now, I don't know about that. I mean, it's a constitutional right to a jury trial. So why would the judge's input be higher than the jury's verdict?
Well, then why else would the remitter rule exist other than to be a shortstop to excessive jury verdicts?
Fair enough. Why can't we just review that on an abuse of discretion standard, like we review so many things?
I think the Creamer case and the other cases have addressed that issue and said that, when the trial court uses its discretion to make these decisions, the Court of Appeals almost always has to decide that the trial court made the right choice because he was the one
and
there.
I want to stop you there,
Sure.
because when you look at this language from Kramer,
Mm-hmm.
it almost begs the question of how can anybody ever appeal a remitter? How can you ever do it?
I think the standard is high, but I think there are, of course, always exceptional circumstances for any case. I don't think this case is one of them.
What's the rationale for that? I really am just asking you,
Sure.
why? Why? Can you tell me why? It's discretion plus. It's this almost insurmountable standard of review. Can you tell me why? If you don't know, that's fine.
I
This
mean,
is something that's interesting
sure.
to me, and I don't understand why this is in our jurisprudence. These are the kind of things I think about when the TV's broken, okay?
Fair enough.
Well, and let me interject, because I think one or both parties cited this very ancient territorial decision
I did.
from 1911, which does give us some guidance. It says, where there has been no error of law committed which would require a retrial, and it appears that the excessive verdict has resulted from too liberal views as to the damages sustained, remission of the excess, instead of putting the parties to the expense of a new trial, promotes justice and puts an end to the litigation. We may not necessarily think that's the most cogent reason, but that is, once again, the Arizona Supreme Court's somewhat aged explanation. I do think, as I said to Mr. Abernathy, the additors and remitters are they're kind of outliers when it comes to the whole notion of the sanctity of jury verdicts.
Well, I think, to briefly answer the question, I think Rule 59I and additors and remitters in general are a unique practice, and it's almost a compromise. Rather than ordering a new trial on all the issues, we're going to compromise and see if plaintiffs will accept this reduced verdict here. Plaintiffs haven't. And so if this court affirms what the trial court did, we're going back down for a new trial. It's not that plaintiffs are going to get $250,000. We're going back for a new trial on damages.
So do you think it's the involvement of the party, in this case it would be the plaintiff, that they can accept or reject it, that makes it different than just a grant of a new trial
I
and
absolutely
insufficiency
do.
of the evidence?
Because, again, plaintiffs get to decide whether or not they accept that amount. It's not the trial court saying, you're getting this. It's, do you want to accept this? And if not, we'll go and have a new trial.
Does that, because.
On damages, I'm sorry.
Because the plaintiff in this case is being given that choice, or has been given that choice, does that, in your view, diminish our appellate review in some fashion?
Can you repeat that question again? I'm sorry, Judge.
Again, and maybe it's not a very clear question, but here, let me try again. Because the plaintiff in the remitter situation is being given a choice of accepting the reduced amount or getting a new trial, does that mean that we have less of a role in reviewing that, which might explain why the Supreme Court found in the Kramer case that every case they looked at of editor or remitter, they affirmed?
I think that definitely is one element to it, absolutely. I also think that the discretion that the trial court has, it just can't be taken with the court here, in the sense that, again, they're the ones who see and evaluate the jury. They're the ones who hear all the evidence. And as this court has already said, it doesn't have the task of reweighing the evidence.
Can I ask you one other question?
Absolutely.
If we applied just a straight abuse of discretion standard, do you still think that we should affirm?
Yes, absolutely.
Okay.
What if, hypothetically, we look at this and we don't really agree with the $250,000?
Mm-hmm.
We think maybe it should have been somewhere in the $300,000 to $500,000 range. What do we do then?
I think at that point you're exercising the discretion that the trial court had.
Well,
I think if
we're bigger.
bigger doesn't always mean right.
I suppose that's right. So we're not supposed to substitute our judgment
I don't
for that
think
of the
so.
trial court, but the
I
trial
don't think
court
so. I
gets
think-
to substitute its judgment for the constitutionally entitled
Again,
right
the
to
trial
by
court was
jury.
there for all the evidence. It sits as the ninth juror.
I mean, had the trial court done something extreme, for example, reducing it to the amount of the medical bills, which, as I
Sure.
recall, were around $41,000.
Correct.
I think all of us would find that to be an abuse of discretion, not giving any additional sums for undisputed pain and suffering and emotional distress. You'd agree with that, right?
Yes, and this court asked for an example of when remitter might rise to the abuse of discretion plus standard. I think that may be one of them. When the trial court reduces the damages all the way down to literally the only actual damages, when there was evidence presented on pain and suffering and other things, I think that may be the one situation or a few situations where that rises to that standard.
And an editor, on the other hand, had the plaintiffs sought an editor and the court, well, I think the analysis is the same. So it gores both sides' oxes when the shoe is, well, I'm not even going to mix metaphors there, but Never mind.
Go ahead.
No, I'm done. I'm quiet now. You quit giving me that look.
No, I want to hear the resolution of these
No,
metaphors.
we're done.
No?
A long afternoon.
It has been.
I'll only make one more point on the abuse of discretion issue. I think the injection during the motion for new trial, added or remitted, or I'm sorry, remitted, of similar jury verdicts, I think that again just shows that the jury verdict in this case was excessive. Now, I completely understand every case is unique. Every case should be decided on its own facts, but it provided an unbiased barometer of jury verdicts involving this injury or this type of injury. And I think when the trial court sits back and reviews everything that it saw at trial and then reviews similar jury verdicts, because quite frankly, I don't know how else the court makes the determination. I think that is another way and reason why this court did not abuse its discretion.
Remind me of the facts. The defense argued that it should be remitted down to about $300,000?
I believe it was $350.
$350?
Mm-hmm.
And is that a permissible part of our review of the judge's discretion that he chose to slice it down to $250?
Again, I think the fact that the court didn't just take what we asked for and gave it right back to us shows that he really reviewed the record, really made a highly discretionary decision that this court should either affirm on a whole or reject on a whole. And again, I asked that the court affirm that what the trial court did. So the fact that he didn't just give us what we asked for, I think shows how much he evaluated what happened at trial and made his determination of what it should be. And again, plaintiffs have the opportunity to accept that, and they haven't. And now we're going back down once this court makes this decision, if in our favor, for a new trial on damages.
Yeah, you make a good point that he didn't just give you what you asked for, and that does certainly show some independent thought and discretion on his part, I suppose. But I think that might also be taken to cut the other way. He granted more than you were asking.
Well, we said not more than 350. So, I mean, we did leave room that it could be less. And again, he could have looked at similar jury verdicts and made that determination. Unless the court has any further questions.
No.
Thank you, Your Honor.
May I ask the first question so I don't lose it here?
You asking me or your colleagues? Because
Yeah.
you outright
better
me.
ask him.
Whoever will let me ask the next question. Judge Gould.
Motion
yes,
denied.
Mr. Abernathy, you said earlier that the $250,000 meant that the judge said it could never be more than that. Something like that. I forget
Correct.
the exact
Yes.
words you used.
Yeah.
I don't quite understand it that way. I understand it to be that the judge was exercising the right given him under our rules and case law to reduce it and to pick a figure that he offers to, in this case, your side, but that he wasn't necessarily saying no jury could ever do more than 250. He's just saying, here's what I think it should have been, and that's what I'm putting into this remittiture.
Well, I think the answer to that is that's exactly what he should not do. And I think when you look at the law, in remittiture, and I had that discussion with the judge too. He said to them they didn't really, why 50% across the board? And I got up and I said to the court, I said, remittiture is only supposed to be in that rare exceptional circumstance where it's shocking the conscience, where you believe an award is so far out of the mainstream, I call it lunar orbit, that you as a judge then take that atmospheric body and you pull it back into orbit.
Where does that shocking the conscience come from? I don't see that in any of the case law. The passion and prejudice and shocking the conscience go with the ordering a new trial, but I don't see shocking the conscience as the standard for a remittiture.
Yeah, I think it's, again, I'd have to look through the cases over
I thought
here.
that was the standard for a complete grant of a new trial, not a remittiture.
Well, the courts, when you do look at the cases, use the word muddled. They often use these concepts sort of interchangeably. Sometimes it's a result-oriented thing that they're doing. I wanted to read, I want to come back to, can I go back to Judge Gamble? I don't want to leave that unanswered.
It'd be good from my standpoint.
Okay, well, if that's all right, Judge Downey, and then I'll come back to. In a remitter, he's supposed to take it from lunar orbit and bring that body of mass back into some orbit. It's not, none of the cases say the judge is then supposed to, having decided that it is in remitter territory, there's no case law that says the judge then decides on the value of the case. That's still not the law. He's supposed to then decide, or she, the trial judge is supposed to decide, what is the highest amount of money that this case would have justified. They do not then become the decision maker. They have to decide how to get it from lunar orbit back to orbit. And orbit does not necessarily have to agree with what they would have done. And so I think sort of the premise to your question is a little off. No, he doesn't get to independently value it at $250.
I'll need to take a further look at it in light of what you just said, but yeah, because it seems to me that it may not be quite the way that you've described it, but perhaps it is. It seems to me if the judge, ordinarily, if the judge thinks the result is in lunar orbit, it's a new trial. Perhaps on damages only, perhaps on everything. Here it would be damages only because that's only what it was in the first place.
Correct. I think that's probably why there was no new trial. It was a stipulated damage trial. I mean,
but so if it's in lunar orbit, that's pretty high up, and ordinarily, if we didn't have this quirky little remitter-to-editor rule, it would just be a new trial or a new trial.
Certainly an option. I mean, Judge Downey.
So now we have, because of this rule, we have the judge authorized to provide an option. He provides an option.
Well, he still has to protect the sanctity. Yeah, okay, but he still has to protect the sanctity. That we keep talking about the sanctity of the verdict, but if they're just words on paper and they're not enforced in reality, then they're just words on paper. What evidence do we have that he was protecting the sanctity of the verdict? There's really none. And Judge Downey, before, and I don't want to run out of time.
Go ahead.
She believed that there was some different stand. The answer to the new trial is they might not have been able to meet it if Judge Downey thinks shocking the conscience is only for the new trial, but not for the remitter. I did want to read, before my time is up, something from the recent PETA case, before I'm quiet.
Go ahead.
But in PETA, I just want to point this out, because I understand, and again, I'm not someone who complains about every judicial complaint at the trial level. It's a hard job, and it needs to get deference. It's like being married and your children's getting punished. And you come home and someone's punished, you say to your wife, in my case, what happened? He's a week in his room, okay? I'm not going to question what happened. Now, if it's a year in the room, I'm going to say, wait, what happened here? And I think when you read from Judge Winthrop, and he says, he says the abuse of discretion standard, and he says, a remitter is a device for reducing excessive verdict to the realm of reason. Remitters should be ordered only for the most cogent reasons, such as a lack of evidence supporting the damages award, which is why we had pages about what the evidence was. Then he says, to answer probably you, Judge Downey, nevertheless, if a verdict is so unfair, unreasonable, and outrageous as to shock the conscience of the court, or is plainly the product of passion, prejudice, mistake, or disregard of the evidence, a court may grant a remitter or new trial. There again, when you said, where am I getting conscience, shocking the conscience, it's right in the PETA case from last year from Judge Winthrop. And then he goes on to say, it is obvious that the test for reviewing the granting or refusing of a trial judge's adjustment of a verdict is complex and can only be solved by an ad hoc approach. Each case will be considered upon its own facts. I think that kind of gets to what you were saying, Judge Gould. That's not language from this court, the Court of Appeals, that is saying we just give sort of this undying allegiance to what the trial judge did. What is an ad hoc basis? I kind of said to myself at one point, it sounds like de facto de novo, like we know enough as judges, we can see if something is that outrageous, honestly, it should be able to shock your conscience too. I mean, that would be my ruling. That would be my theory. If it was so outrageous, the trial court would see it and so would you. That's shocking the conscience. And so if the trial court did not apply the right standard at the trial level, or if he thought, well, no, shock the conscience is only for new trial but not for remitter, well, we have a case from the Court of Appeals here just last year where those concepts, Judge Downey, are all put together, shocking the conscience. And we're going to do an ad hoc approach. Now, what is ad hoc?
Counsel, I think you're out of time.
Okay.
Thank you very much.
Thank you very much.
We'll take this matter under advisement and we'll issue a written decision. Court's in recess.